Good morning. My name is Jordan Walker. I am an attorney with Seaver Walker Paget Law Firm. We are going to go ahead and get started. It is 11 o'clock, and I don't want to keep you guys around here too long. So with that being said, we will go ahead and jump in. Again, my name is Jordan Walker. I am with the law firm of Seaver Walker Paget Law Firm. We are eminent domain attorneys. This is the only type of law we do. This is the only area of law we do, and not only that, we only assist landowners in their eminent domain acquisitions. We don't represent the condemner. We don't represent the takers of land. We only represent landowners. We are a national firm. We have an office in Texas. I am licensed in the state of Texas. We also have offices in other states as well. And we've done this pretty much on a national scale for a while now. And the reason why I tell you that is to let you know that, as a consequence of all of these cases we've done, not only in Texas, but in other states, we've learned quite a bit. We've seen pretty much every situation you can imagine from an eminent domain perspective. Learned a lot, seen how the condemners operate, see how they work. And we've learned a lot. So today we are sharing that experience with you to kind of let you know what we've learned so that you're better prepared when they come through and try to acquire your land for this project specifically. I just recognized I have the wrong, this is not the SH31 project. This is the Loop 9A. That's a error on that first slide. So don't worry, we're talking about the Loop 9 project. You're here for the right webinar. So with that being said, we'll just jump right in. And before I get into eminent domain, I want to talk about the project specifically, but why you got the letter that you got from us. If you received a letter from us, that means that according to our research, your property is on the project that's affected. This is the Loop 9 Segment A project. And not only that, we've learned that at least somewhere on this project, they have acquired some measure of land. They might not have acquired your land. They might have issued an offer yet, but our research indicates they've started somewhere. And it's very hard to time these acquisitions up. It's very hard to time these projects up because the acquisition lasts for so long, especially when the projects are particularly big, and a lot of properties are affected. So if you received a letter, it's because we've recognized your property as one that's affected by this project, and we suspect that at some point in the future, in the next year, maybe, it's hard to nail it down, that you'll receive an offer. So that's why you got the letter from us. So let's talk about the project a little bit. We're not going to talk a ton about it because a lot of times folks know more about the project than we do because they're on the ground. The Loop 9 Segment A project, it's new road, new highway within Dallas and Ellis. As you can see, it starts over near Red Oak, and then it ends there at 67 on the west end. This is a description of what you're talking about. There's going to be a median installed. There's going to be some access control as well, which means there's going to be limited access to the road from adjacent properties. And I think it's important to note at this point that medians are a big part of road projects, road acquisitions, of course. And medians by themselves are not a compensable item. So if your property is affected and they install a median right out in front, prevent a turn into your property, maybe from one of the roadways, going east or west, that in and of itself is not a compensable item. Medians are not compensable. However, if the project, and when I say it's not compensable, I mean you can't get money due to the damages caused by a median on your property. And that is the law, not only in Texas, but in many states. And that's just as an aside. But it's important to note in these acquisitions, I think that's exemplary of something with eminent domain, that being not everything is compensable. You don't get money for every last thing you can think of. There are certain rules to compensation that you need to consider in these situations. Nonetheless, that's the project. That's what they're doing. And with that, as you can see, it passes through Cedar Hill, Ovilla, Glen Heights, and Red Oak. And it's obviously in Dallas County and Ellis County. So real quick, now that we know, have a little bit of information about the project, I want to talk about eminent domain. A lot of people don't know what eminent domain is, so I like to get it out of the way. Some people do, but a lot of people don't, and that's not a problem. It's kind of a unique situation that people find themselves in. Long and short, eminent domain is the forced acquisition of your land for a public purpose. And the public purpose in this instance is a road project. Road projects are de facto public uses, which means that it's very difficult to challenge the acquisition on the public use grounds as irrational, as unnecessary, as problematic this road might be in your personal view. A lot of people don't like road projects that affect their land. The rationality of a road project is generally not up for debate at eminent domain. In other words, you can't show up at court in your eminent domain lawsuit and say, this project doesn't make sense. It shouldn't be built. It's unnecessary. It is going to cause more problems than issues it resolves. That is not an argument. That is not an argument that's going to win you anything, unfortunately. Roads, there's a lot of deference given to roads with eminent domain. So challenging it on those grounds is definitely not is not a good course of action in my view. But regardless, that's all to say that generally speaking, challenging eminent domain is pretty difficult. Your valid challenges to an eminent domain taking would likely be reserved for TxDOT or the acquiring agency not following the landowner bill of rights that exists in the state of Texas, and we'll talk about that in a bit. So, but it is, I will say it is difficult to challenge these takings. And even if you challenge on landowner bill of rights grounds, that's still only going to be a temporary victory because they will just fix their problem and then go through the acquisition process again and acquire your land properly. So again, that's all to say that in these scenarios, it is very difficult to stop these takings. But at the same time, as difficult as it is to stop the acquisition, stop the taking, it is on the flip side, a much fairer fight over getting the right amount of money for your land. In other words, just compensation. So even though the acquiring agency can acquire your land for a public purpose, they still have to pay just compensation. And it's not just compensation, it's just compensation, meaning not only do they have to give you money, they have to give you the right amount of money, and the right amount of money that is encompassing of all the effects on your property such that they are. And a lot of times in these scenarios, the Texas Department of Transportation does not offer fair and just compensation in their initial offers when they attempt to acquire land. And we'll get into that here in a bit. But just bear in mind that they have to give you just compensation, and just compensation isn't necessarily just what they think it's worth. It's what it's actually worth and how it affects your property. And so I want to talk about the eminent domain process. And the eminent domain process in Texas is actually encompassing not only of the litigation portion of it, but also the pre-litigation, meaning TxDOT, any acquiring agency in the state of Texas needs to follow the landowner bill of rights. And I touched on it earlier, I'll talk about it now. Landowner bill of rights in acquiring land under eminent domain, meaning they can't just show up and say, here's an offer and then take you to court the next day. It's not how it works. There are statutory requirements that TxDOT needs to follow before even getting to the point of being able to file a lawsuit. And if they don't follow these requirements, you heard me discuss this in the last slide, if they don't follow these requirements, you do have the opportunity to challenge them not following them, and you can even dismiss the lawsuit, which, again, they can still fix these issues by following these requirements, but you can put yourself in a leveraged position by calling out the DOT not following the law prior to initiating their condemnation petition. So this is the process, the procedure, and I did it on the strictest timeline possible, meaning there are, as part of the Landowner Bill of Rights, as part of Texas law, there are pre-suit negotiation requirements, but there's also timeline requirements, meaning they need to wait a certain period of time between these steps at minimum before they can get to the next step. And these are all time minimums. In other words, this is the absolute quickest it can move in Texas, if possible. Will your acquisition move as quickly as this timeline? Unlikely. It's very likely that there's some time, between more time than is set forth in this schedule. But this is the absolute quickest, so that let's say you run into a buzzsaw and they really need your land as quickly as possible. This is the quickest that they can get to that point from making an offer and getting the litigation. So let's start with the first step, and that is the initial offer. Again, these are statutory requirements. So let's say tomorrow you're issued a written offer from a right-of-way agent trying to acquire your land for this road. They issue the initial offer on day one, and this will be an offer of compensation. It's exactly what it sounds like. It's a monetary offer for your property. They've issued the offer, and then at the minimum, a little over 3 weeks later, day 24, and this would need to be 7 days prior to the final offer. That's the statutory requirement. The acquiring agency will issue the landowner bill of rights to you, meaning they will provide it to you. And I should state that a lot of times the landowner bill of rights, it's actually a copy of it. I should state the copy of the law. They'll likely issue it with the initial offer. Generally they don't wait until this point to issue it, but they have to as a matter of law. But generally they'll issue it before that, meeting their requirement. So they'll probably provide it with the initial offer, but the latest they can offer it would be 7 days prior to the final offer. So you've got the initial offer. 3 weeks later, they sent the landowner bill of rights. And then a week later, and this is assuming, of course, that no deal has been reached between you and the DOT. On day 31, a month after the initial offer, you are provided your written final offer. So as it says right there, it must be in writing, although all this is likely to be in writing anyway. This must be in writing. They need to provide a plat map of the acquisition, although they will probably provide that earlier as well. They will need to provide a copy of the conveying document, what they want from you, whether it's a deed or an easement or some other property interest. Those are generally the only two. And then they must also provide an appraisal report that they've created on the property. And that appraisal report must be equal to, or that should be greater than the report's number. Meaning, if the appraisal says you're entitled to $30,000, they can't issue an offer for $20,000. They have to issue an offer for at least $30,000. And again, these must be in writing, and these will be provided, and they have to be provided as a condition precedent to them filing their lawsuit. And just as a practice note, our firm gets involved as soon as the initial offer is issued, and sometimes sooner, depending on the case. Once you get your offer, you can contact me, and I will look at it for free and give you a free case review if you're interested. And then if you'd like to hire us, we can go from there. But you do not need to hire me in order to get my advice. I can provide it as soon as you get me your offer, and you can decide what you'd like to do. So this is the first part of the eminent domain process. So continued. So you've got the written offer. It's day 31. What happens then? How close are you to litigation? Well, it's possible, although very unlikely, that 2 weeks, about 2 weeks, at least 2 weeks after that written offer is issued, on day 46, the DOT is allowed to sue you. Again, not saying they will, but they could if they wanted to. Legally speaking, they could initiate their lawsuit as soon as 46 days after the initial offer, or 2 weeks after the final written offer. And litigation is an easy way of saying eminent domain. And eminent domain means you are in the legal process. The DOT is going to utilize the judicial system to get your land. What happens then? Well, the petition is filed, the petition for condemnation. You are served a copy of that petition. And as soon as the petition is filed with the court, the judge presiding over your case will appoint a board of commissioners. These board of commissioners must live in the county where the property is located. So, and the purpose of the board of commissioners is to determine preliminary just compensation for your land. So back to the timeline. On day 46, you've been sued. the case has been filed. And then between 40 to, I guess, was that 40 to 70 days later, roughly, or at least 20 days after the board is appointed by the court, and plus another 10 days to strike by either party. So 30 days after they're appointed, at least, I should say. The court will have a hearing. The Board of Commissioners will have a hearing, and the purpose of that hearing is to determine preliminary just compensation owed to the landowner as a result of the taking. The purpose of the preliminary compensation is basically to determine, as you might imagine, a preliminary amount of money that the state or the acquiring agency can deposit with the court, and in exchange for that deposit, the DOT or the acquiring agency gets access to the land to begin construction on your property. So in Texas, the acquiring agency can actually access your property, begin construction before final compensation has been determined. This is the case in many states. It's commonly referred to as a quick take method in other states, although it is the standard method in Texas for acquisition. So the BOC, the Board of Commissioners, makes their preliminary determination. The DOT deposits the money with the court. They get access to the land. It is very important that if you disagree with the preliminary compensation amount, if either party disagrees with the preliminary compensation amount, whether it's the DOT or the landowner, they need to timely object to that amount. So, for example, let's say that the Board of Commissioners are determined, and you present evidence. You think you're entitled to $200,000 for your land. The Board of Commissioners disagrees. They don't think you're entitled to 200. They think you're entitled to 100. What happens then? Well, if you want to get that 200 and you are dead certain that you're entitled to that, then you can disagree, file an objection, and it needs to be timely made, meaning you need to file it timely after the Board of Commissioners has determined the amount. And if you don't timely file those objections, the case is over. And you get whatever that amount is that the Board of Commissioners determined. There's no jury trial. There's nothing else. That's that. Either party can disagree on this amount. The DOT can disagree. The landowner can disagree. If either party disagrees, the case continues on down the track of and eventually, if getting to that point, a jury trial over final just compensation. So it's important to remember that if you don't disagree with that amount, but you actually don't think it's fair, it doesn't matter because your case is over. So if you disagree, you need to file a timely objection. The DOT will do the same thing if they disagree, but you need to do your own objection if you disagree. This is a compressed and aggressive schedule, relatively speaking. Again, that's if they follow it, and there's a decent chance it's not going to be as tight as this, but it's important to prepare for the worst, and it's possible that they just blast through it if they're in a hurry and all of a sudden you're in court. So just keep that in mind as you go through this process, as you get offers and so on, that it's good to be prepared for a quick and tight schedule just in case it's not. And now I want to talk about what to do when you receive an offer from the DOT. So we talked about the initial offer, and this is in reference to the initial offer, though you can do it for the written one as well. I generally advise to say, as soon as you get that offer, talk to an attorney and get back in touch with the right-of-way agent. A process or a method of doing this to protect yourself that I've devised is set forth in this slide. What I tell people to do when dealing with right-of-way agents is to, first of all, insist that they communicate only via email and that they send their offer via email. Try to keep all of your communications with the right-of-way agents, with the DOT, to a writing. Try to make sure all the communications are via email, via text, mail, if necessary, anything where a writing is created. I generally don't advise getting into verbal discussions with these folks because they are not particularly helpful. It is better to have all these things on the record, so to speak. Right-of-way agents will make all sorts of verbal promises, verbal assertions, and those don't mean anything for purposes of your land. What matters is what is in writing and what are they willing to do. If they're willing to do something, getting them to verbally say something means nothing. You want them to have it on the writing so you can point back at it later and say, look, you already agreed to do this. But beyond that, I generally don't advise getting involved in these discussions without first, even discussions via email. I generally don't advise getting involved in those without first talking to an attorney to get an understanding of what your case is and what you're looking to accomplish, how much money you're looking to get. It isn't a good idea to just jump into negotiations with right-of-way agents. You can say things that you think might be true and might be fair, but ultimately may not be. As an example of this would be, let's say they offer you $25,000 for your land, and your initial compulsion is to double it and say, give me 50. And they say, nope, we're only giving you 25. And then you hire, and then you go, and then they file their lawsuit. And now you're in court, and you have an attorney involved. You hire our firm, and we say, well, I don't know if 50 was right. I think 100 might have been better. The problem is that they already know that you take 50 because the right-of-way agent that you were dealing with, just like you're keeping copious notes of these discussions, they will write down everything you say, and they will keep it with their file. And your file continues on with the attorney, and it'll stay with you forever. Meaning, when you made that initial overture, or after their initial overture of $25,000, when you said, I'll take 50, and you actually should have been getting 100. Now, when you come to them at 100, they say, well, we knew you would have taken 50, so here's 50. So it's just important not to get bogged down in these negotiations, especially when they can't necessarily do what you want them to do. You want to make sure these offers that you make to the DOT are smart and comprehensive, and include everything that you're entitled to. So what I tell people to do, a very easy process, is to, as soon as you get the offer, insist, first of all, that they only communicate with you via email. Insist that they send an offer to you via email. And then when you get the offer, say, thank you, I will review this and get back to you in a week. The reason why this is a helpful response is that, one, you're not blowing them off. Meaning, if this is a case that maybe doesn't go to eminent domain, telling them you'll respond in a week is not going to, it gives them enough comfort to know that, okay, a week is fine. They can respond. We don't need to head to eminent domain immediately. But a week also gives you enough time to do your due diligence, maybe talk to an attorney, get a feel for what you should do, how you're going to respond, and then go from there. You don't have a ton of time in these scenarios, but you do have some time. And a week isn't going to upset anybody, and it gives you enough time to develop a schedule, a plan, and a strategy. What not to do when you receive an offer. Again, I've already touched on this. Don't engage and jump into value discussions without first talking to an attorney. Do not enlist an appraiser unless instructed to by your attorney. A lot of people, because they get their appraisal, a lot of people feel the need to go out and get their own. The reality is that eminent domain appraisals are very expensive. And if you don't need to spend that type of money on one to get where you would get anyway, then I generally don't recommend that you get one. Appraisals, in my view, are only really necessary when you reach litigation. And I generally don't like to spend my clients' money, so I generally don't get them until they're absolutely necessary. In my view, they're not absolutely necessary generally until litigation. So if you can get the same result without spending a ton of money on an eminent domain appraisal, then that's the best result for everybody. So I generally don't recommend getting one. I'm not saying you might not need one eventually, but if you can save the money, you might as well save it. Don't meet in person with the right-of-way agent. Already talked about that. Don't jump into a quick decision. We already talked about that. Give yourself a week and then respond. But also don't ignore it altogether. I have a lot of folks that get an offer, put it aside, don't want to deal with it, and all of a sudden they're in court. It's important to remember that if you are at eminent domain, it should be because you want to be in eminent domain, because that's the only venue where you can get just compensation. Because if the DOT is not willing to negotiate with you and they're giving you no option but to pursue your legal rights at eminent domain, then that's a good place to be. If you're at eminent domain because you ignored the offer forever, didn't do anything with it, and then all of a sudden you're in court and now you're spending money that maybe you don't want to spend, that's a situation that you want to avoid. So don't ignore it, but also don't jump into a quick decision. So, sorry, just a real quick, I want to change this because this has not been changed. Okay. I want to talk about hiring an attorney. Hiring an attorney, I can only speak for our firm and how we operate. Our firm operates on a contingency fee basis. And a contingency fee is basically a fee that's contingent on how well we do. A very easy example of how our firm operates is the bullet point number 3. Let's say your offer is $10,000. You hire our firm and we get you $100,000. Our firm takes a third of the value that we add to the case. In that scenario, it would be a third of the 90 that we add to the case. If you hire our firm and we don't get you one more dollar than what was initially offered, we don't collect a fee. So what that should tell you is that if we take you on as a client, it's because we see real value there. We see a real recovery, not only for you, but for us, because in this scenario, we are partners effectively. I want to add as well that, in this scenario, there are not upfront costs. If you want to hire our firm, it's as simple as signing a contract. You don't need to write me a check. You don't need to send me any money. It's signing a contract and we get to work. The check comes out at the end, and that's us writing you a check for the net proceeds. So we like it that way because it keeps everybody assured of the goal, and that is getting the best possible result. We do it this way to provide some peace of mind to landowners to know that they don't need to know us from the beginning. They don't need to intimately know us to hire us as their attorneys, because they can be assured that we like money and we're attorneys, and that's you can be assured that our interests are your interests because your interests are our interests. So I'll leave it at that, but that's how we like to operate. If you want to operate on a different type of relationship, we can absolutely talk about that. We do billing, billable, and retainers and all that as well. So feel free to contact me if that's something you're interested in. So I have reached roughly the end of this presentation. If you guys have questions, feel free to kind of add some right now, and I can address them once I'm done talking here. Moving forward, what I would tell you is to seek out representation when you receive your offer. If you haven't, you can even reach out ahead of your offer. If you're not sure what's going on, you want to learn a little bit more, you can give me a call at 737-252-1936. You can also text me at 470-869-1383. You can email me at jordan@swp-legal.com. Feel free to send me questions that maybe you come up with later. But with that being said, my final comments to you would be to not rush into a decision. Rush decisions are usually the bad decision. You have time, but not a ton of time. So you need to be a little bit more vigilant than maybe you'd expect on these. And then finally, this is your only chance at compensation. There's no takebacks once the documents are signed. So I think it's imperative and incumbent on landowners to, do their due diligence, exhaust, every possible avenue to see if this is the right deal and that you're getting the right deal for your land, because this is the only chance you got. So with that being said, I will open up for questions if there are any. Okay. It doesn't look like there are any questions. So thank you for joining me today. I appreciate it. If you have any questions, feel free to give me a call, shoot me an email. I'm happy to answer anything. Other than that, thank you for all stopping by. I appreciate it. This webinar will be on demand. So if you want to take a look at it later, just head on back to the website, or you should get an email also with a link to the recording. Otherwise, thanks for stopping by. Good luck, and contact me with questions.